McNeese, you wish to speak to the motion at all?
Sure, Your Honor. Just briefly for the record, this was originally an Aspire account opened back in October of 2021 with a last pay date of September 2022.
Welcome to a high-stakes courtroom session where eviction notices, debt claims, and strict legal procedures collide in real time. Today, City of Sturgis and multiple financial cases push for decisive rulings. Watch every decision reshape lives instantly. Stay tuned for courtroom drama breakdowns. Subscribe, like, share for more stories now.
All right, I got people in the waiting room. I kept trying to let them in. It is 1:40. Someone's here by telephone. Who is then the phone that ends in 448?
This is Jason Kohler.
All right. This is a second hearing in this manner. The file number is 2688-LT. It's entitled City of Sturgis versus Jason Kohler. City of Sturgis owns the dam, Sturgis Dam. These houses are on Sturgis Dam Road, which is a little short dead-end road with what were caretakers' homes on them. And the city wants to get rid of their tenants. So we were here on 227. The city is still asking that you move, and I told you if they got what they asked for, you would have until March 19th to vacate. Have you had any success in moving any of your stuff?
Yeah, I've started moving my stuff. I plan on being out before the 19th.
Very good. Mr. Reed, what do you want him to do with the keys?
I would have him coordinate with Mr. Root there at the city to ensure that the keys are returned in a manner that is convenient for both parties.
All right. The law requires that when you do vacate, you turn in your keys and give your forwarding address in writing within 4 days of your moving. I'm not issuing any money judgment at this time. This is simply a possession judgment. 10 days from today is the 19th of March. As we discussed, this includes the house, the outbuildings, and everything on the property. I did see that the ice went out last week. The day the ice went out, the Amish kids were already out there fishing in a boat. The water's gonna be awful cold if it only falls in, but as I said, this is an interesting little road, beautiful view out over the mill pond, and but the city wants the property back, and you understand the circumstance. Yeah. You've got until March 19th to vacate. Coordinate with Mr. Root, the city facilities manager, on what to do with the keys, and make sure you give them your forwarding address in writing within 4 days of your moving. Mr. Reed did submit a judgment, which I have filled out. Anything further? Do you have any questions, Mr. Kohler?
No, everything's pretty clear.
All right, very good.
Thank you, Your
Mr.
Honor.
Reed. Mr.
Thank you.
Root. All right, this is the part where we switch gears for a minute to our general civil cases. We have 3 of them. So we have portfolio recovery versus Rebecca McAllister. Who's here on that matter?
I'm here for portfolio recovery, Your Honor.
All right, I don't see Rebecca McAllister, so we'll set this aside for just a moment. Next, we have Sturgis Hospital versus Jessica Harris. That is Timothy Frost, and he is present. Somebody's in the Zoom room. What's your name, ma'am?
Rebecca McAllister. It was the portfolio one.
Got it. And then we have Citibank versus Stacy Moyer. Anybody here on that?
I'm here representing Citibank, Your Honor.
And that's Preston Nate.
Correct.
Good afternoon, Mr. Nate. And we have Jefferson Capital versus Erica Brown. And that's Weber and Olsees. Is that you, Miss McNeese, as well?
It is, Your Honor, yes.
All right, well, let's start with that one.
Okay.
This is file 252407. GC, Jefferson Capital versus Erica Brown. The claim is for $1,464.29. Hannah McNeese is here for the plaintiff. And Erica Brown is here via Zoom. P82477.
Here, the judge explains summary disposition, a powerful procedural tool that ends cases without trial when no material facts exist. The defendant's general denial fails legally, showing how procedural rules override emotion. Debt buyers win by documentation, not argument. Do you think courts move too fast in these situations today?
The lawsuit was served on the defendant, and the defendant filed an answer in pro per, a general denial of all the claims. Actually did a pretty good job of it, filed a general answer and denial. That gets you past the default. It does not necessarily get you past a motion for summary disposition. The plaintiff claims that there is no material issue of fact, and you have not stated a defense. A general denial isn't a defense. It just, as I said, gets you past default, but not past summary disposition. Ms. McNeese, you wish to speak to the motion at all?
Sure, Your Honor. Just briefly for the record, this was originally an Aspire account opened back in October of 2021 with the last pay date of September 2022. As you noted, the deficiency balance left on the card was $1,466.29. This was subsequently assigned to my client, Jefferson Capital. No objections to any statements or any monthly invoices. As you noted, the defendant filed an answer. However, I believe there are no valid defenses pled, and I don't think there was a counter affidavit filed either. We filed the motion for summary disposition, and defendant failed to submit a response, which is required under the court rules. So pursuant to MCR 2.116 C9 and C10, no valid defenses and no genuine issue as to any material fact. Plaintiff is requesting judgment be entered at this time.
Ms. Brown, what's your response?
I've been working with Beyond Finance. I did follow up with them a few days ago to see how things were looking. And they said that they've tried reaching out to them multiple times. And every time they reach out, they've been redirected to talk to somebody else and never being able to really directly speak with anyone.
Well, even if we enter a judgment, Beyond Finance can still work with them to try to rectify this debt.
Correct.
Now, you heard Ms. McNeese eloquently rattle off the court rule 2.66 C9 and C10. Lawyers use it all the time, and judges. summary disposition is a foreign notion to lay people, but essentially it means there is no material issue of fact and you haven't stated a defense, and a judgment should simply enter on their behalf. And I believe they're correct. So I'm going to grant that motion for summary disposition. Now, when you get this, I want you to share it with Beyond Finance. Just because a judgment entered doesn't mean you can't continue to contend to compromise or resolve this debt. The amount is for $1,466.29 plus court costs, filing, service fee, and a statutory attorney fee for a total of $1,595.09. Are you still at the US 12 Lot 10 address?
Yes, I am.
I will send that to you. I suggest you share this forthwith with Beyond Finance. And we'll send you a copy of that order. Do you have any questions?
No, not right now.
All right, you're good to go. I'll send you this $1,595.09.
Thank you.
All right. Thank you. Our next matter is portfolio recovery versus Rebecca McAllister. Once again, Hannah McNeese is here for Weber and Olsees. This was a claim for $2,097.92. That lawsuit was served upon the defendant, and the defendant filed an answer. A default judgment entered, and defendant has filed a motion to set aside the default. Now let's back up. The date of the judgment was April 30th of 2025. The defendant failed to make her installment payments in November of 2025. I waited until January. No additional payments were made, and I set the installment payment order aside. Then on February the 6th, you wrote a letter essentially asking for a new installment payment order, claiming that you had made the payments. The amount isn't huge, 2,000 and some, but I end up having a motion to set aside the installment payments, then a motion for installment payments. We end up chasing our tail. So I generally set it for a hearing, get both parties here at the same time. Ms. McNeese, what's Weber and Olsees' position on this?
So, Your Honor, currently, it looks like $1,250 is due and owing at this time. We're not opposed to a payment plan. There's been no stability by way of payments, or regularity, I guess is the more appropriate word. So not opposed to a reasonable payment arrangement. Or just seems like kind of keep coming back to this.
Ms. McAllister, what's your position?
Well, I've been off work since January 7th with my back, and I have not been back to work. So they're only paying me 50% of my wages. And on 1/7, I sent a money order for $150. And on 1/29, I called $300 in out of my checking account. And that's about where we're at. I don't have any answers to when
Ms. McNeese, do you show those payments?
Yes, Your Honor.
This moment exposes real courtroom tension, as payment history, hardship claims, and inconsistent installments collide. The judge carefully balances fairness with enforcement, reducing garnishment risk but demanding structure. It shows how debt law blends empathy with discipline. Is a $100 plan truly sustainable for struggling defendants under pressure now?